So this is something I found out about just today in doing research for this case. I did not know that this is a thing that existed. Because when Congress is upset that the executive is not giving them information, they have traditionally had two powers. One, they can refer a criminal case of contempt for contempt of Congress. The problem there is that the executive branch gets to decide who to prosecute, and of course, they're not going to prosecute themselves. They also have a civil power where they can go to court and ask for things civilly. The problem there is twofold. A, it takes a long time, and B, courts still decline to hear a lot of these cases because of the political nature of them. They don't decline to hear all of them, but they do decline to hear some because of the political issue. But there is option number 3, which we're going to discuss, that I just learned about today. Today I learned. The current dispute between Democrats in the House of Representatives and Attorney General William Barr, this was going back to May when this was a thing, but will be relevant to our current issue, could result in contempt. So what contempt powers does Congress possess that they can use? The House Judiciary Committee is considering issuing a contempt citation against Barr. In turn, the Justice Department has said the House subpoena does not serve a legitimate legislative purpose. Yeah, we're going to subpoena you and hold you in contempt, and then we're going to hold you in contempt, and you're the Attorney General, and you have to decide whether to prosecute yourself. We know how that's going to go. Based on precedent, statute, and court rulings, the Senate, House and Senate each have power to invoke three kinds of contempt proceedings. I was only aware of 2. We're going to learn about number 3. We'll just skip ahead. The third type of contempt power, Congress's dormant inherent contempt power, is rarely used in modern times. Inherent contempt was the mode employed by Congress to directly enforce contempt rulings under its own constitutional authority until criminal and civil contempt statutes were passed and remained in use into the 20th century. Under inherent contempt proceedings, the House or Senate has its sergeant at arms or deputy take the person into custody for proceedings in Congress. So apparently, under case law and under statutory law, Congress can authorize the sergeant at arms, who is a legislative official, to arrest someone and hold them until the trial. And I found out they used to have a jail in the basement of the Congress building. It's been since turned into office space, but they used to have a jail down there, and you could put someone in that jail by legislative fiat. Apparently, this is a thing that used to exist. Up until like the 1920s was the last time it was used. So I did not know this was a thing. So hypothetically speaking, Congress could issue a subpoena to, say, Rudy Giuliani, and Rudy Giuliani could refuse, and they say, we're holding our inherent contempt power. And then they tell the sergeant at arms, who again is a legislative official, to go and arrest him and drag him down to the basement and lock him into an office, I guess. So that's a thing that could happen. I thought that was entertaining.
Oh, wow. But that might look bad on Congress.
It might look bad. I'm just saying this is an option that existed. I was unaware that this is an option. Although these powers are not directly stated in the Constitution, the Supreme Court has ruled on multiple occasions they're implicit as an essential legislative power held by Congress. Justice Willius Van Devanter perhaps made the most famous statement of these powers in McGrain versus Doughty, a 1927 Supreme Court decision about Mally S. Doughty, the brother of the former Attorney General Harry Doughty. A select Senate committee issued a subpoena for Doughty to testify and also surrender records from an Ohio bank. When Doughty refused to comply after the second subpoena, the Senate passed a resolution issuing a warrant and authorizing the Senate deputy to take Doughty into custody. Doughty filed a habeas proceedings against this detention. The lower court ruled that the Senate had exceeded its powers by detaining Doughty, freeing him. However, the Supreme Court upheld the conviction, holding that under the Constitution, Congress has the power to compel witnesses and testimony to obtain information in aid of the legislative function. So the U.S. Supreme Court has ruled that the United States Congress can unilaterally arrest someone on their own initiative. This is a thing that apparently exists. I did not know. Each House of Congress has power through its own process to compel a private individual to appear before one of its committees and give testimony needed to enable it to efficiently exercise the legislative function brought under the Constitution. This has long supported in the Houses separately and repeated acts of Congress, all amounting to a practical construction of the Constitution. Tactical.
So when Lewandowski testified before Congress, he frequently invoked executive privilege and said, I've been advised not to answer questions about my conversations with the president because it could fall under executive privilege. And Congress was very not happy with that. And in fact, they were sort of saying that because he was never an employee of the executive
Right.
and he was not officially doing any executive related duties, that his conversations would not fall under executive privilege. Now, I didn't hear anything in that Supreme Court ruling about limiting that privilege only to employees for the executive
Right.
or government officials. Um, After reading that ruling, do you have any opinion on whether executive privilege would apply to unhired, unpaid advisors that are not employees?
Well, I have mixed feelings on the issue because, on the one hand, like everyone who is a federal official has to take an oath of office and the oath to the Constitution, right? So there's an idea that every member of the US government is bound to obey the Constitution. And so you could say that every member of the executive branch and cabinet officials is implicitly aware of their responsibilities to the president and would not just repeat them willy nilly. If you brought in a random, if they brought in a random third party, if they brought in you, to have a conversation with the president, the idea that you might tell people what happened is not absurd because you don't have any particular like loyalty or duty. You're not even an American citizen. So like that's my dominant answer. There is a contra idea in my mind that the president might want advice from someone who's not in his inside his government, because the president might have a special issue and he might want special advice from a specific person for some reason. So, like, well, maybe he should have that, but if that other person, tells about it, then, like, where's the privilege imply? Because, privilege requires both people to, like, be aware, at least in some level, that there is a secrecy. And if the other person, you know, I mean, I guess the president could whisper to you, this conversation's secret. Please don't tell anyone. So I don't know how that would play. I mean, the court case doesn't deal with it. It hasn't come up. Now,
Okay.
Rudy Giuliani's argument is going to be attorney-client privilege, but the problem there is it's not 100% clear to me that Rudy Giuliani has necessarily been acting in the capacity as an attorney. Just because you're an attorney doesn't mean everything you do is attorney-client. I'm an attorney. I'm talking to you. That doesn't make what we're doing attorney-client. Not for at least the reasons that a lot of people are listening, and third party shatters the privilege if it existed, which it didn't anyway. But it's like, you don't need to be an attorney to have a conversation about the law. So it's like this is not, attorney gives me knowledge, but it doesn't make this an act of an attorney. So a lot of things Rudy Giuliani has been doing are not things attorneys do. So you can make a credible argument that some or all of what he's doing is not covered by attorney-client privilege, which will be hilarious if that ever comes to be.